Good evening, everyone. You will have to understand that I was born after the technology, so I'm struggling a bit, but I believe that I'll succeed. Good evening, everyone. I would like to first take an opportunity to thank the Wesley Guild SA team by affording me this opportunity to share my legal knowledge with my fellow Methodist people, even those who are not Methodist people. I believe that I'm covering South Africa, even beyond the borders of South Africa. So let me greet you, everyone, the young people and those who are young at heart. Today I am tasked to talk about the law of succession. We know that everyone is struggling when it comes to this kind of law. It is something that is very, very much prevalent at our areas. It is something that caused a havoc after someone has passed away. Then I believe that the administrators of this group noticed that problem after someone has passed on. When we talk of law of succession, we are talking about wills and estates. And when we talk of will, or when we talk of wills and estate, we are talking about testate succession and intestate succession. What does it mean to be a testate succession? Okay, let me try to clarify. A person can die intestate and a person can die testate. What does it mean to be intestate? When a person dies without having a will, that person is having an intestate succession. Therefore, the customary laws will apply. But when a person dies testate, that person who is having a drafted will. What is will and who must have a will? A will is a wish of any person as long as he is over 18 years. A person, a normal person, it does not have, or it does not mean that a person who can have a will must any person can draft his or her wishes, and a will must be signed. A will must be signed in the presence of two witnesses. Those are the formalities or requirements of a valid will. Those witnesses, it might not be a people from your family, but it is any person who is above the age of 18 years, 18 and above, let me say so. A person who can attest to what, or to the contents of the will. That person is a witness. So at least the maximum of the witnesses must be two when you are drafting a will. Who can assist you in drafting a will? I believe that even banks can assist you to draft your will. When you are drafting a will, you just go to a person who will keep that document for you, and there must be someone who knows that you are having a will. When you are drafting a will, the contents of the will must be lawful, in the sense that you cannot say something that is unlawful in your will. To say that my kids or Msimelelo Qumntu will benefit such and such only if he kills his mother. So that is not a valid will once it is having conditions that are illegal. And when we talk of a will, a valid will, it can be done by any institution, bank institution. It can be done by a legal person, an attorney, not advocate, attorney, a law firm. And after you've drafted, signed your will, that will must be kept safe by an attorney, and you must also have a copy. You cannot give someone a copy of your will whilst you are still alive, especially a beneficiary. So the beneficiaries must not see what is contained in your will. We know the worst scenario, that you can be even killed by those beneficiaries so that they can benefit quicker. What is happening when you passed on without a will? Oh, let me say this first. A will is treated as a paramount document after someone has passed on by South African laws. Not unless, even though it is paramount by our constitution, but it is not treated paramount if you have done something that is contrary to the laws of the Republic. Ndithini xa nditshoyo? When someone drafts his will and excludes his wife, or let me not make an example by the spouse, but excludes his kids for the maintenance. Let's say you are having a child inside your homestead, inside your house, but in that will you are saying that that child must not benefit in your estate. Your wife can be able to challenge the contents of your will, or any person who is having an interest of that particular child can be able to challenge that particular contents of the will. A will, you can draft a will, or you can die testate, but your will be invalidated by the Master of High Court if you fail to adhere the requirements of the will. A will must be signed at the end. Let's say it is having more than one page. It must be signed by the testator. A testator is the person who is the owner of the will. That person, if he is a male, it is a testator. If he is a female, she is a testatrix. So that person must sign the will at the end of the document, in the presence of the two witnesses and a commissioner of oath. A commissioner of oath is a person like an attorney or a police official or anyone who is declared as a commissioner of oath. I believe that even the police officials, not all are commissioners. So only those who are declared as commissioners of oath. Let me come that let me say that you died testate. After you've died testate, the first thing that the beneficiaries or the people who left behind must do is to approach an attorney or approach a Master of High Court or magistrate, estate office, with the document, and that person will verify or will check the document whether it is a valid document or not. Then if you are having an assets that are more than 125,000 rand, you will be referred to the Master of High Court, where you will get a certificate, an executor. When we talk of executorship, you can appoint your executorship in your estate, or you can just say that anyone from this kind, you can appoint an attorney or you can appoint someone from your family. What is happening now that you died testate and your estate has been reported? Then everything, every asset that belongs to you, there is something called inventory form where everything is being written down. If you are having immovable properties, movable properties, claims in favor of estates, and so forth, those things are included, in fact, are written down on that particular form. And there must be a total at the end of that form. And the total, okay, let us not concentrate much on the total and on the requirements of the registration on the administration of estate. Let us come to the intestate. Let's say you died without a will. You don't have parents, but you do have children. All your children will benefit out of your estate equally. I forgot to clarify that when you're having a will, the beneficiaries benefits according to your wish. And once you are intestate, deceased, all your children will benefit equally. It does not matter whether this person or this child does not belong to your marriage. We called a children born out of wedlock. As long it is your child, that child supposed to get his or her share equally like the children of the marriage. Sorry. Let's say you are married and you do have your children, and for argument's sake you are having 500,000. Your wife will get 50% of your estate automatically. When we talk of 50%, that is not it is his, it is his or her share in your estate. He must have his 50%. After he or she has taken this 50%, then again you have a right, or you are entitled to get a fair share in the amount that is being left after the spousal share has been deducted. It means that, let's say you are having a 500,000, you will get 250,000 and left 250,000. You come as a spouse and check whether you can be treated as a child, or you can take 125,000. I'm not sure exactly about the amount, but the last time I checked it was 125,000. So in many cases, the spouses, especially the spouse when he or she does not have children of him or her, he usually gets the bigger amount. Ndicela ukuyicacisa ngesintu banda kwethu. This lo muntu une 500,000 as an estate. Then his spouse is entitled to 50%, which is 250,000, and kushiye ku 250,000. And kulo 250,000 ushiye kuleyo une right or entitled ndoba aphinda azofumana ishare yakhe. Uyifumana ishare yakhe ke ujonga imali enkulu. It's either ufumana 125,000, or if le mali izawufika ibe nkulu ufika athi hayi ke ndifuna ufumana nabantwana ngokulinganayo. So ixhomekeka yena intoba ubonile intoba le mali inkulu kweliphini icala. So that is an intestate succession, intestate administration of an estate. Then let us come to the issue where there is a children that is being disputed as a child of the deceased. Once there is a dispute kwi-estate yomuntu, especially kwi-intestate estate, the best option is to take that particular child before kwenziwe i-distribution, or before abantu bafumana ishare zabo. Kuyiwe kwindawo apho kuzawuhlolwa khona amagazi to verify whether this child indeed is a child of the deceased. If there is a claim and you are disputing that claim, you have to follow that route. You cannot make a distribution of an estate if there is an estate. If there is a claim against estate, especially a maintenance claim. I am not sure whether is there any question regarding to the intestate and intestate succession. I would like to touch on the issue of the person, of the deceased, having two wives. Ukuba yona kwenzeka ntoni na. Just a minute. Unfortunately, I was in court today. Sorry about that. So my phone is flat. I even laying down the kuyo is not my place. So ndiyasokola kakhulu. Hence ndingena charger. Ndise court as we speak. So hopefully you will bear with me about such inconvenience. I really apologize. But let me continue. Hopefully disavelile. Another issue, in fact, if this person is having more than one marriage, obvious imitshato ayizufana, there will be a civil marriage and a customary marriage. But both marriages are very, very recognized by South African Court of Law. Okay, there is this question. Indeed, Mr. Sigwabe, the DNA yenziwa nomntwana who is not in dispute that this child is the child of the deceased. And it is up to the family. This child angayenziwa i-DNA ne-siblings zika-deceased if zisekhona. If bafilish into yoba even the child ekubizwa into yoba ngaba ka-deceased are not, in fact, are not the offsprings of the deceased. Therefore, ingenziwa ke ngoku ne-sibling ka-deceased. As long as kuza kwenziwa i-DNA nomuntu onegazi lika-deceased. Then kulo mcimbi ke ngoku benithetha ngawo ndondonqene uyeka lambuzo because ngoku le phone ndiyibambe ngesandla nikwazi ukubamba ipen now ndixolele. The issue of a person who is having more than one marriage, it is very, very complicated, but it is very, very easy. If the marriage, the customary marriage is or has followed all the necessary steps to be recognized as a marriage, that person is also entitled to get her share as a spouse of the deceased. Ndithini xa nditshoyo because bendithethe ngo-50% ngaphambili. Ngoku ndithetha ngezipouses, ngabafazi ababini. What do I mean when I'm saying that she is also supposed to get ishare yakhe naye? Ndibuyela kulaa mzekelo we-500,000. That the 50% of that amount does not change, is 250,000. Whether bafazi by 5, but 50% of that amount which the wives of the deceased will share is that 250,000. I think I'm clear kuleyo into that this 500 does not, this 50% does not belong to one, but it belongs to all the spouses, the surviving spouses of the deceased. Then let me come to the issue of administration of estate, where this person is having a will, a testate administration of estate. Obviously, this person appointed someone who will administrate his estate, and that person will do according to the wishes of the deceased. Number one, that estate, whether it's intestate or testate, that estate must be reported to the Master of High Court or to the magistrate court. There is an office there called estate office. Then this person who is an administrator, whether is an attorney or a family member, must make sure that he advertises this estate, that anyone who is having a debt against this estate must pay that debt to the local newspaper and to a government gazette. And also, he must also advertise that all the people who are having a claim against the estate or against the deceased must lodge their claims within 21 days. You cannot just distribute an estate without a publication to invite all the people who are being owed by the deceased to come and to lodge their claim. And awunakwazi ukudistributor an estate got deceased without calling all the debtors of the deceased to pay their debts, even if uyazazi, even if awuzazi. Funeka kwenziwe lo publication. I am not sure whether ndisaphendula yona na okanye. Okay, there is a question from Mr. Ndanjana. No, Mr. Ndanjana. When kuthethwa ngomthetho, legally there is no great wife. All the wives are equal. It is only in the customary law when there is a great house and a right house. So this 50% belongs to the wives of the deceased. I think that is all for today. Not unless there can be a question. Don't because bendi only 30 minutes and daqonda ba mandithi qhwi lo mcimbi we wills and estates, then dilishane ne testate and intestate will, dilishane ne administration of estate. So I believe that for today that is all, and I believe that if you are having a question around the issue that I've just said, you can just give me inbox if you don't have my number. Thank you very much.